move on to the slide, I just would like to share something. How the context of medical negligence litigation is evolving. You remember last time when I was talking to you, I did inquire from you, rather elicited from you, your concerns about medical litigation. I am sure every one of us we have concerns depending upon our own background. If I am a lawyer, I have my own concern. As a patient, you have your own concern. As a service provider, you have your own. As an attendee of the patient, you have your own concern. Therefore, more or less the concerns we try to elicit with a view to drive home a kind of a larger picture you need to envisage. Okay? Come to the next specialty, OBGYNs. LSCS, I told you the problem. But doctors also have a problem. Please don't think that only patients have a problem with the doctor. Doctors also have a problem. Let me share one important. It so happened, I am very happy to say that. Because of my intervention, did not go to the court of law. One day I received a call around 10:30 in the night. That is the time for me to read newspapers. She called, Jogaro, I want your presence urgently. I said, where are you? I am in the labor room. What will I do in labor room? What is the need for my presence? No, you do not know. There is a very complex cases here. Correct, complex case for you, not for a lawyer. No, legal issues involved. Are you sure? Yes. Pregnant mother's mother, one group. Pregnant mother's husband and his father, mother, one group. Okay? Now, the actual condition of the baby or the mother is that she may deliver normal delivery. Okay? But husband's mother is very keen. No, she must be done C-section and I want the baby. When? Before 12:32. Muhurtam has already been fixed. If it is after 32, Rahu Kalam, I don't want the baby. She, not mother, mother's mother. No, mother-in-law, rather pregnant mother's mother-in-law. Then husband, no, I want to respect my mother's views, we have to do something about it, etc. Then this group, if it is a normal delivery, God's given gift, whenever it delivers, let the mother deliver. In the process something happens, what do we do? Are you responsible? That's what they asked son-in-law. But son-in-law doesn't talk to their mother. Pregnant mother's mother, he only talks to his mother. Already friction. Then I said, okay, what should I do? What should I do? I understand respective claims, etc. I am a lawyer. That mother, pregnant mother with pain and suffering, she is there. What should we do? No, this is the problem, Jogaro. Then I asked, forget about everybody. Tell me what you want to do. Doctor, you want me to tell the truth? I said, yes, of course, yes. Why false truth? No, I think I should do this. Cesarean. Okay. Is it a professional judgment or a judgment influenced by persons, I asked. No, I want to do it because they are asking. Okay. Suppose something happens. What kind of thing? It could be VVF or it could be UVF or some other problem. What do we do? No, husband gives it in writing, Jogara. What he gives in writing? That he is not going to file a case in the event of any problem. Therefore, why should I bother? Now tell me how much more you are getting. Yeah, 8 to 10 times more I will get my fee. I said, these are very, very objectionable, ridiculous decision you are taking. I am surprised a software engineer working in such a company, he wants you to do this. And his mother, with all respect to your age, you know, 2 lives are involved here. You are a professional doctor. If something happens, judge will not ask whether you got it anything from the husband. Judge will ask, are you a doctor or a nurse? Nurse means you follow the instruction of somebody. Here, if you are a doctor, you should follow your own judgment. You know what happened? When the discussions are on, she delivered normally. And it so happened before 12:32. It is such a nice feeling, such a nice feeling. I mean, I can tell you sometimes it happens, very peculiar incidents, some negative also, but positively, this is one thing I felt, yes, this is something we really. Why I am saying is LSCS not only for the patient, even for doctors there is a problem, please remember. Many a time doctors tell that, I mean, that is one important question which in a Foxy meeting I have addressed. I was asked to, one doctor asked me, a very good friend of mine, she was my student as well, quite young doctor, brilliant doctor, based in Bangalore, no more other details. She said, as a woman, is it not my autonomy to decide that I do not want to deliver, I want you to retrieve the baby. It's my fundamental right, that's what she claimed. She said reproductive autonomy. I don't want to undergo delivery. I said, yes, there is a point in what you say. However, please remember, the right discourse is always subject to scientific processes. Scientific process, you and I cannot take a decision. I mean, that girl, lady is also a mother at that time, therefore she was speaking, but she is a gynec. I said, you can't take a decision. Let some other doctor take a decision, which is in the best interest of both, either baby or the mother. Therefore, autonomy cannot be extended further to say, no, I want to undergo only this because I don't want to bear the pain. No, that I think is a bit of too stretching. That, I mean, I think these kind of issues have come about, but otherwise, as I told you, gynec cases even now, lots of cases pertaining to the issues, LSCS and subsequent problems. Tubectomy I mentioned here only with regard to conception. You remember last classes also I mentioned. But otherwise, some other times, pulmonary embolism or some other kind of thing, sometimes a blood clot, I mean, very, very serious consequences. But otherwise, I can tell you, majority of these cases, the mother or the husband, if the mother is no more, they get favorable judgments. Favorable judgment. Court asks the doctor to pay compensation. I have seen my own experience, majority of gynec cases, they get compensation. You know why? Sympathetic to the kind of situation, 30-year-old woman dies or 32-year-old small baby. I mean, whatever said and done, judges are also human beings, they are from our own society. Please remember. I mean, that's how it happens. Yeah, sometimes it can be justified, sometimes it could be, but otherwise these are the. In this particular gynec, whatever the situation, the entire, this is one thing area I want to discuss. You heard about multiple sclerosis. Have you heard about a case where after forceps delivery, mother started suffering multiple sclerosis and mother claims it is only because of forceps delivery she developed MS. This particular problem has taken place and she had problem in squatting, sitting, standing, etc., knee down, and she came to NIMHANS. In the NIMHANS history, see, history writing every one of us we do know, but we write sometimes in such a manner without realizing what you have written will convey. You don't realize. What happened? This is the problem, etc., etc., etc. She is suffering from this, the thing, etc. 2 months back, the thing has been conducted. Both, if you read, this is something I always see in medical negligence cases. One important legal issue is causa causans, that is, the injury which is alleged to have taken place must be only due to the direct cause of my negligent conduct. If it is remotely related, then there is no negligence. Scientifically, there must be a direct cause. It is a fundamental principle. On that principle only we have won the case. I said, in fact, a judge asked, he is a very interesting judge. He asked, show me any literature where they have said MS is not caused by forceps delivery. I said, your lordship, you please give me a condition, rather a warranty that you are not going to sleep when I speak. Normally afternoon he sleeps in between. 1 day, 2 days I was continuing. Then third time I thought the best thing is I also stopped. My voice is metallic voice. It's very difficult for people to sleep. But judge used to sleep. 1 day I stopped. Then what happened? Then I understood, this is the method to wake him up. You break give a pass, then he will get up. I said the problem here is, in medical literature, anything that is possible will be written on the basis of the study that has been conducted. In scientific research, no study is conducted to rule out the possible or potential. You agree? Yes. You agree or you don't agree? In law, there is a possibility. The way you interpret law, you can rule out the possibility. But in a scientific research, doesn't happen. Therefore, I will not be able to find a literature which says, no, MS is not caused due to forceps delivery. I can only say, what are the possible consequences of forceps delivery? In that list, there is no MS. He appreciated, and luckily, I mentioned, he said, I just put a very rosy sentence. He was very happy. He asked, what do you think everything is fine? I said, I always have confidence in your sense of justice. I said. I was so happy. Sense of justice. That is, you sleep and that is. Like that, we have closed and we got a favorable. Okay, move on to the next important area, orthos. The number of cases are increasing for orthos. What are those issues? Very peculiar. Breaking implanted metal plate, very common. In fact, one doctor said, when it is implanted, if it doesn't break, what happens? It has to break one day or the other. Nerve injury, transcervical neck femur, osteosynthesis, 3 unscrews, non-union. Compound fractures, the most problem, like a Bangalore traffic jam. In ortho practice, the major problem is compound fractures and lingering infection. T-plate fixation, metal allergy. Couple of cases, very serious cases. Avian femoral head, deep vein thrombosis of common iliac. And multiple fractures, first, second, third surgeries. Let me generalize the ortho problem. Ortho problem, what I understood is that, please pardon me for my observation, but it is a reality. Normally, the patient doesn't get relief with one surgery. Normal. Suppose if the patient got with one surgery, he is great. First surgery leads to second surgery. Second surgery leads to third surgery with one limb. Fourth surgery, patient goes. I will tell you the problems involved. I mentioned Karnataka Ortho Society KOS is there, regular annual. Last conference I mentioned this. In fact, one senior doctor, he did say that I don't agree with you third, fourth, etc., but first, second are very common. I said, next year conference, you will agree third and fourth. What is the problem? I will wait for one more year. That is the reality, because, here the problem is, we are living in a competitive environment. Some of you are from government hospitals. You don't feel that competitive environment. But in private medical practice, there is tremendous medical competition. In such a manner, I myself saw, I was in a hospital talking to a doctor, somebody came, this is the thing, I said, Jogar, if you don't mind, can I just, I said, no problem. Is he your patient, I asked. No, he may be my patient. What is that? How a person can be potential patient? I was thinking. Then he said, no, if you want to be there, you can be there. I said, okay, let me get a chance. Normally, no doctor invites me to be there. He asked. Then he said, what? Only this. The doctor who conducted surgery, he used only 3. I would have used 6 screws. That sentence is enough. He is not a potential patient. He is the patient of the doctor. One dialogue. Finished. Then he said some this, that, etc. Do you have still problem? It will continue. Then second, the way he talked in my presence, I told him this. Normally we talk to, otherwise they don't understand. That's what he says. Okay, I understood, that is a different matter. Why I am saying this thing is, ortho surgeries, please remember, there is very, very crucial input from the patient. Please understand, unlike in other specialties, the constructive contribution from the patient is equally important in ortho cases. Either load bearing or this or instruction or using even a toilet facility, using what circumstances, what way. Everything is so important. Even your movement with stick, movement with this, etc. I mean, unless and until the constructive contribution takes place as in the instructed, the relief may not take place. Majority of the cases, the patients do not follow. First one. Second thing is, I mean, the competition with regard to implantations has become so huge. On one hand, in good olden days, please correct me if I am wrong, implantation injury was quite expensive in good olden days, but now the cost has drastically come down. Even the cost of the implant also has come down drastically. Therefore, unless you get more number of cases, how do you get more number of cases? You have to do the second surgery even though it is not required. That's how the competition, etc. And I can tell almost all these problems were orthos. In fact, you will be surprised to know, whenever any kind of orthosurgical intervention, the informed consent process, unlike in other specialties, it is much more crucial here. You know why? You need to talk to the patient about the implant, the kind of structure, the quality, for example, allergy. Will it cause allergy? In one case, the caused allergy, etc., the leg was amputated. The person said, you didn't tell me. No, you wanted only 10,000 below. No. I said, correct, but you could have told me 10,000 with allergy, 15,000 without allergy. Now, what happened? 10,000, I got allergy, but I lost my leg. He filed a case for 15 lakhs. He got 7.85 lakhs. I am telling you, the way the communication is so important in ortho practice. Unfortunately, the standards, etc. And there are so many players in the market. I mean, this is the surgeons. I did mention to you last time also, as I told you, I am sure after 10-15 years, I don't think there will be a specialty called surgeons. That's true. General surgery, even now, you don't, already it is oblivion, and most probably it is the specialty specific surgical intervention. That's it. Cardiac, neuro, etc. LSCS laparotomy, I told you, no? I mean, this is one important area where it is such a simple problem, but at the same time, let me make an observation. In medical negligence cases, there is another problem I face. If only one doctor is involved of one specialty, the problems are minimal. If two doctors are involved or more than two of the same specialty, the problems are more complex. Same subject. And particularly the problems are more complex if the two surgeries take place in two different hospitals. In fact, mudslinging is so much, I can tell you, it's terrible. Ultimately, everybody is interested in only one thing, whether the patient will leave the hospital without surgery or with surgery, rather before surgery or after surgery. That is the major problem, and that is a reality in Indian circumstances. As a result, you will be surprised. One case I can tell you, even today, the decision, we got a bad decision, but I really feel that there is nothing, no fault on the part of my doctor. The fault was somewhere else, but they have covered up in such a manner, beautiful makeup has been done. Simple case, LSCS, delivered, baby was no problem. After 39 hours, please remember, she started developing breathlessness. ECG has been taken, bedtime scan has been taken, everything has been taken, no fluid was found, nothing, and she was referred to the major hospital. From Tumkur to Bangalore, Tumkur is a neighboring district, it takes roughly 60 to 70 minutes. Okay, good road, that is the reason why. The patient was brought to the one hospital, shifted to another hospital, shifted to another hospital. Ultimately, she died in this hospital, fourth hospital, because they could not do anything by then. The second hospital gave a report by saying, we have done laparotomy and we realized 1000 milliliter blood clot was there. How come the LSCS people have not noticed? As a result, multi-organ failure, this, that, etc. Here the problem is, how do you decide? If it is a 1000 ml blood clot, would it be unnoticeable? Whether your bed scan, will it reveal something? Will it not reveal? We are not talking about 10 milliliter or 20 milliliter, 200 milliliter. We are talking 1000 ml. I mean, these kind of problems take place where always there is a urban-rural divide. and the kind of practice this, that, etc. I mean, there is a kind of unwritten say, no, in rural areas care is not proper.
Easy to blame.
That's so well. And then comes the most significant one, hernia, fissurectomy. In fact, fissurectomy has become a much more very, very difficult case for me. Even now, I am not clear about that problem. Even now, I have read like anything. I discussed with doctors like, this is one area, may tell you, exterior part and interior part. Which one is to be cut? First one interior, first thing. One doctor says, no, Jogara, with the right you cut, with the left you cut. The other, no, right you do this, this. Nobody follows one textbook. And everybody claims their own expertise. And ultimately what happened? Judge got confused. He said, what is this Jogara? It is such a difficult. No, that's how the reality. And accordingly, they asked us to pay 3 lakhs or something. We filed appeal. I mean, what I want to tell you is the surgical practice doesn't conform to an established medical practice. That is the problem with surgery. On what basis you can say whether there is a deviation or not? And ENT surgeons, for your information, hydropneumothorax, you know, small children in India, I am sure in every country, the problem is the child swallows coin. You have seen 5 rupee coin in India? No, no, you have seen. Thick one,
Yes.
so, and rough edges, he swallowed that. And ENT, very senior surgeon, etc., he has done that, what is scopy, what do you call esophagoscopy, correct, correct, that is the thing, and is identified, and he saw blood coin with, the 5 rupee coin with blood stain. Then he thought nothing to, he removed, and etc., he asked him to take some banana, etc., and accordingly, and third day developed a lot of problems, shifted to major center, etc., thorax, the problem. Now the issue is, the blood stained 5 rupee coin, is it on account of esophagoscopy, or is it on account of the coin itself that got bleeding? You understand? If you say that it is esophagoscopy as the problem, then negligent conduct. If it is on account of 5 rupee coin, then there is no negligence. We tried our level best to say that the fact that he saw the blood stain and he removed the scopy, he did not pursue further. That itself indicates that it is not due to esophagoscopy, but it is on account of the. But the judge felt no. He felt that no. In fact, if that is the kind of situation, he should not have undertaken the case. He should have referred to the major center. That's what judge felt, and accordingly negligence has been recorded against the doctor. What I want to tell you is, sometimes it is so difficult for anybody to decide whether there is negligence on the part of the doctor. If so, how do you? What is the yardstick? What is that measurement process? Very, very complicated. In fact, I got expert evidence from one doctor, and he also said it's difficult for me to say is it due to the scopy or. But the complainant's lawyer, he argued beautifully with a lot of drama and all. He said, your lordship, he has put it like this, he has done. I said, you would have died within 2 seconds if you do that. What is this? Is it like getting water from a well or what? I mean, you can't do that drama, and judge may believe also. I mean, he may think that with what speed you do, that is good for the boy. I said, no, it doesn't happen that way. Was he present? The way he is talking? No, was it under anesthesia? I said, there is no need for anesthesia. Please. It is not that, but at the same time, there are complications. That is one thing. I mean, what I want to tell you is, I mean, see, 80-year-old boy, I mean, all they had spent around 3 lakh rupees. I mean, it was life-threatening in the major center. I mean, all these factors enable the judge to, no, you should not have undertaken. I mean, without deciding whether it is negligence or not, he said, no, he ought to have referred him to some other center quickly.
Judge of this sort, not, thank you,
Yeah.
not qualified in medical profession to sit over judgment on such issues.
Correct.
Does anything strongly prohibit having a medical person as a judge for these cases alone? Go for, seek always, of course, regular judges' help in interpretation of law.
You are absolutely right. In fact, I fully concur with you. But the problem, my problems from the field, what I can share with you is, many a time doctor is also on the panel. Many a time, it's not every court, but generally. But the problem is, I am sorry for my observation, the judge is quite, he bulldozes. I mean, you know, when I said it's not very matured, you know what, I mean, the specific interpretative process doesn't happen. You got the point. I mean, whatever certain in medical science is something unpredictable, something uncertain, that is something every one of us we need to understand. I mean, no, they don't accept that. No, why did he take responsibility of that? He could have referred that. I mean, see, in my case also, I said that it is not due to the negligent conduct. It is on account of the swallowing of the coin itself. That's my argument. You may not accept. I don't have, but he decided on the ground, no, you should have been referred to some. That I feel something, you don't address the issue properly, but at the same time you want to be sympathetic. I am not saying that doctor cannot be negligent, please remember. Even now I am saying, why only doctor? Any one of us can be negligent. But the method in which you have to identify, that is something. You may ask why judges normally react this way. There are reasons for that. In fact, some of the judges, they told me. They said, Jogaro, you have studied law and you are teaching medical law, therefore you are a familiar person. But a patient doesn't know anything. He only knows about the adversarial consequence that took place. And the burden of proof is on that part. Generally, lawyers are not familiar with medical law. And they do not know, they do not appreciate. Which means every medical litigation case must be resulted in favor of the doctor only. Is it right? We find some kind of processes, some inputs, which may not be objective all the way. Please remember, that's what judge told me. But with our own limited understanding, that's how we do it. Because in India now, whatever said and done, the market economy influencing healthcare delivery is something a reality. As a result, the doctor-patient relationship, please remember, it has some kind of problem. What is that? Whenever the patient comes to a doctor, the doctor thinks whether there can be a potential litigant in Jogaro. I mean, that's all. What patient we think, he doesn't know whether it is quarter-final or semi-final or final, how many doctors he has to. That's the truth. Don't you agree? No, I go, he says some particular thing, angina. Is it angina or how do I know? Go to second doctor. He will say, no, angina is some other problem. He will go to third doctor. We do not know. Which means there is a mistrust between the relationship. If there is that mistrust, naturally, please remember, you go in for your own process of defending, I go in for my own process of protecting. That is the result of medical litigation. Even now, I can tell you, I conclude with one sentence. If a doctor communicates with the patient, I know so many doctors, they communicate well. Even there is a death, take it from me, the patient comes around and says, I understand whatever possible you could do. Leave it at that level. Several incidents. But the doctor who doesn't have time to speak to the patient, who was arrogant or who wants to charge, etc., then naturally. Similarly, because the cost is involved, I mean, patients are also not innocent, please remember. Suppose death takes place, bill comes 70,000. Oh, you give dead body and bill also. Huh? You give dead body and you want bill also. No question of payment. Discount, 10,000, 50,000. I agree that both sides, see, everybody wants to exploit. I mean, see, after all, society is one and only, no. We are talking about the same society. If you want to exploit in your own medical way, I want to exploit in my own economical way. That is the reality. Therefore, what we are aspiring for, some kind of sense to prevail, I think it is a long way to go. But definitely I can say, there are three important pointers. Number one, on one hand, there is a growing awareness about patient rights in general public, number one. Number two, the most significant one, the role of the state in healthcare is almost disappearing. Third one, unless some economic process is identified to take care about healthcare, what is going to happen is the so-called people who can't afford will come and take service from you, there is private, and they will not pay. That will result in a law and order problem, that kind of crisis situation. You know what are the two aspects Amartya Sen said India must look into? What are those two? Education and health. Please remember, these are the two aspects which this country must focus on.
Healthcare also, he said public healthcare.
Absolutely. Whenever we say healthcare, public healthcare, please remember, we are only concerned about one who cannot afford. Please remember, a person who can afford, that's fine. There is no. I am not saying that he has no rights. No, even a person who can afford also rights, and the doctor also who collects money has a responsibility. But I think in the larger perspective, unless these issues are addressed, I think the social paradigm of medical litigation is going to have such kind of upheaval. To that effect, you need to know what actually we are facing.
Just one question. This is actually related to research.
Okay.
In a trial, suppose something goes wrong. Can the participant file a case against the investigator or the ethics committee or the sponsor? And would it be a case of medical negligence? And what is the status in India right now?
As far as in India is, in Indian context, as I told you, clarity is not there, but clarity is there, pardon me, to one or two individuals. Not many people know. But if it spreads, people will take advantage. The situation is, a subject who is undergoing trial is entitled to initiate medical negligence case against the investigator, the institution and the sponsor, undoubtedly, no questions. Even ethics also, medical ethics committee also, a case can be filed. A criminal case can also be filed, no problem at all. But the issue here is whether it is on account of medical negligence or not. Please remember, in a doctor-patient relationship, relatively it is easier. But in a clinical trial setting, it's very difficult. You know why? In a clinical trial, everything takes place in the four-wall. Absolutely. But in the case of, but your other question, whether a case can be filed against ethics committee member. I, as an ethics committee member, I always felt that there are two possible responses. Number one, even now, ethics committee members, by and large, they are giving voluntary service and they are doing, because there is no financial budget or there is no compensation for services, etc., etc. Suppose if it happens, I don't think many people will come forward to shoulder the responsibility of this. That does not mean that only when they get money to be made accountable. No, even though they don't receive money also, they should be made accountable. When it comes to whether a case can be filed, in India, as of now, it's a very fluid situation. Invoking common law, a case can definitely be filed. That's what I think. Suppose you give an approval to a particular study without or overlooking the patient or subject's concern, a case can be filed. As of now, a repetition before the Supreme Court, where they are collecting details, that's all. Because they asked a question which your updated ICMR guidelines has mentioned. That is, whether an ethics committee is a registered body. As of now, it is not a registered body. It is just an individual or institution driven body. That's it. But now I think slowly we are getting into a kind of a regulated mold. When it happens, definitely, and I can assure you, Dr. Hemlata, in future, after 5 years, number of cases will be in clinical trial. Number of cases. In fact, with a clinical trial, ethics committee, one cell is required. You have to have a cell which deals only with litigation. The kind of commercial element that is involved in clinical trial, please remember, naturally people. But for that, your background will be very, very useful.
Sir, actually, I have learned that in your syllabus itself, you are being taught medical aspects also. Likewise, I also learned that you have higher studies wherein you specialize in different laws like environmental law, medical law and like. So, can't there be a specialized group of
medical law?
Not medical law, judges who are into various systems, and a group who can take up this cases specialized to that particular
in
area.
fact, see, whatever said and done, even legal practice also, from the conventional mode, we are slowly getting into the focused mode. And I am sure in the future it is going to take. So already many institutions, they started teaching. Slowly, development. Definitely, 1 second, our other friend, he raised his hand, but not voice. That is nice of him. Now he will raise his voice. Yes.
Thank you. No, I just wanted to comment that in Kenya, the way I had said earlier, we have a peer committee which has been set up by the medical board, which has to make a recommendation in such cases. And then the judge has to read the recommendation from the peer group, the medical peer group, which will help him or her in making a decision.
Very good.
Yeah.
In fact, to tell you that that's what we are looking into now. My only problem is, as of now, in reality, medical community, they are facing some other challenges in their own profession. You know, the medical body, so many other problems we are facing. Therefore, not much focus is given to this area. Maybe in future, I think we will. Thank you very much.